Hello and welcome to LiveLaw. My name is Padmakshi Sharma and today we will be talking about the recent writ petition filed by the social media giant Twitter against the Indian government in the Karnataka High Court. Fresh trouble seems to be brewing between the microblogging and the social networking website Twitter and the Indian government yet again. Twitter has filed a writ petition in the Karnataka High Court in Bangalore, challenging a recent order from the Indian government for the social media company to remove content and block dozens of accounts in India. To provide a brief background, in June 2022, the Ministry of Electronics and Information Technology, Government of India, served Twitter a letter setting out serious consequences of non-compliance, including but not limited to initiating criminal proceedings against Twitter's Chief Compliance Officer and granted last opportunity to comply with a series of blocking orders which were issued under Section 69A of India's Information Technology Act 2000. Under Section 69A of the IT Act, the central government of India or its authorized officers can seek to block access to information in the interest of sovereignty and integrity of India, defense and security of the state, friendly relations with other foreign states, or in the interest of public order. Non-compliance to the new policies will mean that the platform will lose its intermediary status, which provides them immunity against being liable for any data shared or hosted on their platform as per Section 79(1) of the IT Act. The tension between Twitter and the Indian government has only been escalating since February 25, 2021, when India's new social media rules, that is the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021 were enacted, making tech giants more accountable for the content they allow their users to upload on their platforms. As per the rules, the Indian government had asked Twitter to act on content related to Khalistan and accounts eulogizing terrorists in Kashmir, among other things. To avoid losing liability exemptions, Twitter in February 2021 itself had permanently blocked more than 500 accounts and moved an unspecified number of others from view within India. In June, Twitter also submitted a separate list of over 80 accounts and tweets that it blocked based on the Indian government's request in the year 2021. Twitter has now chosen to challenge and sought to quash 39 blocking orders issued by the government under Section 69A through the legal mechanism of a writ petition before the High Court of Karnataka. These blocking orders are being challenged for being substantively and procedurally non-compliant with the government's blocking powers under Section 69A of the IT Act. That is, they demonstrate excessive use of powers and are disproportionate. For example, in several cases, there are demands of entire accounts to be blocked instead of specific tweets being blocked. Twitter has contended that as the nature of some of the content could be merely political speech, criticism, and newsworthy content, these blocking orders do not pass the test of the grounds provided under Section 69A. Several blocking orders that were issued to Twitter only cite the ground of Section 69A but fail to demonstrate how the content falls within those grounds or how the said content is violative of Section 69A. Twitter has also alleged that the government has abused its power by disproportionately blocking information, and its actions are in violation of the freedom of speech guaranteed to Indian users of the platform. Account level blocking, as per Twitter, is a principally disproportionate measure and violates rights of users under the Indian Constitution especially when the reason stated to block URLs and the reason stated to block an account lack specificity and merely cite grounds under Section 69A. Through its petition, Twitter highlighted that the Ministry of Electronics and Information Technology itself, in various filings in the Delhi High Court, had stated that if only some portion or some content is unlawful, then the platform may take proportionate action of removing such alleged information alone and should not completely suspend the user account. Thus, alternatively, the platform has suggested that the government specify explicit tweets that violate Section 69A for blocking as opposed to revoking accounts entirely. This writ petition is part of a broadening battle between the biggest tech companies and governments across the globe over who gets to control information and how. A date is yet to be set for a judge to review Twitter's petition, and we are yet to see if the social media giant will be successful in its petition against the Indian government. Thank you for watching LiveLaw. If you like our videos, please subscribe to our channel for similar content.